I don't know. I understand the dilemma that this poses for the court, but I see zero utility in returning her to jail. On the other hand, I see a great deal of utility in placing her on supervision.
People of the state of Michigan versus Carlin Gunnett.
That's Mr. Harris.
These are case numbers 244039 FY and 254578 FY. Counsel, on the new file, we're here for a probable cause conference, and on the old file for a probation violation hearing. I know we were here last week and tried to do a plea. The court had indicated that it probably would not follow the proposed agreement. So where are we at, counsel?
Your Honor, I did have an opportunity to speak with Mr. Schaefer, the victim, by the phone. He does support 4A and did echo that she needs to stay on her medication. For that reason, I am repeating the offer.
Mr. Harrison.
I believe I tasked myself with verifying some information. I was likely unable to do so. I'm going to check our notes. Mr. Heiniger was involved with, who incidentally is this Rekka's grandfather. I did not know that. Has been in contact with her. Wasn't sure you were still working. And I don't see anything, Your Honor. I don't know if that renders anything moot here that I said before, and I will continue to request that the court consider the agreement that we put before you last week.
Well, having been presented with nothing more than I was last week, other than the alleged victim is in favor of it, the court is not inclined to go along. Well, I won't say inclined. The court will not go along with the 4A. So with that said, I know we're at PCC. What do you want to do, Mr. Harris?
Check the exact, there was an offer made. I just want to make sure we're talking the same thing. That's what I thought. Okay.
And I'll just state on the record again why I will not follow the 4A agreement. And that is the reason I won't follow the 4A agreement is due to Ms. Gunnett currently being on a delay of sentence. With the result of that case, that she would be the charges would be dismissed. She's here for a probation violation on that file. The report in that file from the probation department, their recommendation was that we terminate probation unsuccessfully. If I recall, last time we were here, it was brought up that she had been successful for about 4 months or so while on probation, but that left about 6 months that she had not been on probation, been successful with probation. And then as laid out in that report, 3 different show causes were held for her for missing random tests and reports. I do not find she is a good candidate for probation under 4A. And for those reasons, that is why I would not follow the agreement. So I'll turn back over to counsel. I know you sidebarred there. Do we have a resolution in this case?
We believe we do, Your Honor.
All right, and what is that resolution?
Your Honor, if the defendant pleads guilty to domestic violence, the people will dismiss R&O.
All right, and then the bond violation then is that she had behavior, new criminal behavior for resist and obstruct and domestic. Are we moving forward on both of those allegations then, or just one?
It would just be the domestic violence.
The domestic.
Yeah, for the probation file, Your Honor.
Right. Mr. Harrison?
I think that's the most expedient way through it.
Ms. Gunna, have you heard what the attorneys have said the resolution in this case is?
Yes.
Or these cases?
Yes.
And is that how you wish to resolve them? So it's my understanding you'll, in the new file, you'll plead guilty to the domestic violence, which is a 93-day misdemeanor, and the people will dismiss the 2-year felony of police officer resist obstruct. In the in the probation violation file, you'll plead guilty to the domestic violence, and the resist and obstruct violation will be dismissed in that case as well.
Yes, sir.
That's how you wish to resolve these? Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in these matters will be the truth, the whole truth, and nothing but the truth? You may put your hand down. Other than the plea agreements in this case, has anybody promised you anything in order to get you to plead? Has anybody threatened you in any way? I can't hear you.
No, sir.
And is it your own free choice to plead?
Yes.
We already know you were on probation at the time that the new offense arose. Mr. Carnes, are you aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
Mr. Harrison, are you?
Nor am I.
Ms. Gunna, do you remember reading and signing the advice and rights form in this file? Talk about your rights to an attorney and your rights to a trial.
What did you say? Sorry.
Do you remember reading and signing an advice and rights form? It talked about your rights to an attorney and your rights to a trial.
Yes.
Do you remember that?
Yeah.
Most importantly, do you understand that you have a right to a jury trial in the new file, and that by entering a guilty plea, you'll be giving up that right? You won't have a trial of any kind. Do you understand that?
Yeah. Yes, sir.
All right. And you still wish to waive the right to a trial?
Yeah.
Hey there, sorry to interrupt the video, but I wanted to take a moment to let you know that TCF is a channel that is 100% human created and human driven. There's so much AI slop out there on YouTube right now, especially in the LawTube space, that I think it's important to point out that every video that we have here on this channel is human created, human curated. We make all the decisions, we do all the editing, it's all us. So if you appreciate that human touch and that human interaction, please do consider subscribing to the channel if you aren't already. Leave us a comment on the video, put a thumbs up. Those things really help us. And if you want even more human interaction, consider joining us for our live show every weekday morning. Okay, sorry to interrupt. Back to the video.
Then to the allegation that on or about October 28th, 2025 in Antioch Township of Wexford County, how do you plead to count number 2 of domestic violence? Guilty or not guilty?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. And before we move further, I want you to understand that by entering a guilty plea in this file, that will automatically enter the guilty plea in the probation violation file. Do you understand that?
Yeah. Yes.
You understand that?
I think so.
So what that means is because the allegations are essentially the same, that you created, you picked up new criminal behavior for the domestic violence. So if you plead guilty to domestic violence and you make out a factual basis for that, that can then be used in the probation violation file. Do you understand that?
Okay, yeah.
All right. So in order to accept the guilty plea, I must have you tell me what it is that makes you guilty. So what happened back on October 28th? Were you in some sort of domestic relationship with Noah Schaefer?
Yes, kinda.
Okay, explain. What do you mean by kinda? What was your relationship?
We were fighting. I wanted to exit the premises.
Let's back up a little bit.
Go ahead.
Were you and Noah living together?
Yeah, for like a year.
Okay.
So you were boyfriend, girlfriend?
Mhm.
You're the girlfriend part of that?
Yeah,
Okay. And that night, October 28th, you'd gotten into an argument of some sort?
yes,
Had you been drinking that night?
yes.
Okay. And at one point, did you tell Noah that you were going to drive away in a vehicle?
Yeah, he took my keys because it was the
Okay.
smarter option.
Okay, so in effect, he was preventing you from committing a crime.
Yeah.
Okay. And at the time, that rather upset you, did it not?
Yeah.
Okay, did you engage in verbal assaults of him? You called him names or
Yeah.
silly like that?
Yeah.
And did you shove him a couple of times in your frustration?
Yes.
Okay. Did he ask you to shove him?
No.
Okay, he didn't invite it. It was
No.
unwanted
Right,
shoving.
yeah.
Okay, thank you. I believe we've established a factual basis, Your Honor.
Ms. Gunnett, did that happen in Antioch Township?
Yes.
All right. Mr. Carnes, do you believe the defendants provided a factual basis to accept the plea and the court rules been complied with?
Yes, Your Honor.
Mr. Harrison?
Yeah, so inclined as well.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Gunnett, I find you guilty of domestic violence pursuant to the plea agreement. The resist and obstruct a police officer will be dismissed. Then turning to the probation violation file, how do you plead to violating your probation by committing a new crime of domestic violence?
Yeah.
You plead guilty to that?
Yeah. I'm guilty.
All right. And counsel, based on the factual basis given in 25458 FY, is there any objection to the court taking that factual basis and applying it towards the probation violation to find a factual basis?
None whatsoever. No.
As such, then I do find the defendant violated her probation by obtaining a new criminal charge of domestic violence. Has everybody received the probation department's recommendation?
Yes, Your Honor.
I believe there is an amended one.
Yes.
Mr. Harrison, did you receive that? Any allocution to both files?
Yeah, and I don't know what else I need to project to the court here. I think our initial posture in this case and the ensuing discussion / argument that accompanied our original request to handle this matter pursuant to 4A, and I don't wish to revisit the court's finding. You've established a record there. But I think that discussion informed the court of what the situation is here. I'm deeply concerned for Carlin as a person. She does have a mental health concern that she needs to attend to. They're doing the best they can to manage the jail. And I'm not casting aspersions on anybody or trying to shift the blame away from where it lies. She made choices that night that she just told you about that have led her to be here. I often discuss these circumstances with clients, and I say there's two other pieces of information that are useful in a criminal proceeding. And one is an explanation and one is an excuse. Well, she doesn't have an excuse. The mere fact that she had neglected to take her meds, or that, as some people in her situation often experience, the meds she's taking are no longer effective in the dosage in which she's taking them, whatever the case may be. That's not an excuse that's legally recognized under the laws of the state of Michigan. It does provide us with one heck of an explanation of the frantic nature of her behavior on that evening. And I think additional insight is provided by the rather understanding posture adopted by Noah in response to this. I think that tells us a lot about his level of understanding and his level of concern for her well-being as well. It's not lost on either one of us. I mean, she and I, that his well-being is important and needs to be recognized too. I think that's why we came to the conclusion that she would take responsibility for the choices she made that night. I don't know. I understand the dilemma that this poses for the court, but I see zero utility in returning her to jail. On the other hand, I see a great deal of utility in placing her on supervision, despite her shortcomings and her shortfalls with the carrot and stick approach adopted on the delayed sentence. I think this is something that she needs to be so cognizant of and so aware of, that the structure provided by being on probation will allow her to do that. If that's more than she can reasonably undertake on her own volition, she agrees that she would seek a higher level of intervention with regard to her mental health as well. She's seen the effect that this has had certainly on her, so sitting in jail. But wider scoped than that, Your Honor, this has affected almost every aspect of her life, certainly her relationships, and things of that nature. She is at the point at which she cannot continue the way she's going, and she knows that. I would like to see her get a chance to reassert herself to be the independent, vibrant young person she was until about 6 or 8 months ago, when something happened with regard to her mental health that she doesn't fully even grasp at this point either. I think the most effective way for her to do that is to have the responsibility to report to probation, to say, look, I've been to my counselor, I've seen my doc, I've gotten this medicine prescribed, I'm on this plan, I'm seeking employment. That provides her with the accountability that I think may have been lacking in her prior situation, and reminds her on a daily basis that she needs to stay on track, or she will be returned to the Wexford Hilton wearing an orange suit that she doesn't like either. I think that's an important distinction that she can make now, and I would, I don't know what the word is, request that the court give her that opportunity. Thank you.
Thank you, Mr. Kynes.
Thank you, Your Honor.
Is there any victim input?
I kind of went over it earlier. The victim opposes any severe punishment. He thinks she needs to stay on top of her mental health treatment and to stay on her medication. That's the victim's viewpoint on this. And I largely share that. One small point of concern, you kind of mentioned, well, usually alcohol is the problem, but I'm concerned with someone taking mental health medications, drinking, because the two interfere with each other. I hope this has been a wake-up call and she realizes that she absolutely can't drink and absolutely must stay on top of treatment with CMH and medication. The police report does state she punched the victim in the chest, landed one hit, as well as punching him. Police report also states she was accusing him of cheating on her I'm not trying to get in anyone's personal life, but it's my guess from talking with the victim and reading the police report that was not the case. Again, I don't need to know, I don't want to know. It's not an appropriate response, even if he was, but I am concerned for the defendant's mental health here. I disagree with probation's recommendation here for 45 days jail. This is her first time sitting in jail and she's sat 13 days. I think a 15-day jail sentence is enough to hopefully get her attention and get her on track. I think it is appropriate to terminate probation and revoke HIDA in one case. I would ask for a term of probation in the new domestic violence case at the court's discretion. And I think a 15-day jail sentence is appropriate for both files. I'd ask the court to impose that. Thank you.
All right, just a question. You said revoke HIDA. This is a delay of sentence, right?
An unsuccessful delay. I am very
Right.
confused because I have both noted in the file and it wasn't my file.
Yeah.
She would be HIDA eligible, so.
The judgment was not a HIDA.
Okay, I take your word for it.
How, in the 24 case, what happened with the resist and obstruct? What was that?
The state police were called to Cadillac emergency room, Munson ER. She was screaming profanities, saying she was not going to stay there. She was staying in the hospital due to a petition at that time. The state trooper Gildy arrived, advised her she was not to leave. He told her to stop. She ignored his commands. She reached for the main ER door. Trooper placed his right hand on her left arm. She pulled away. He then wrapped both arms around the defendant and she kicked backwards twice, striking his right knee. Was able to gain compliance by the wall and handcuffing.
Ms. Gunnett, you have the right to address the court before sentencing. Is there anything you'd like me to know?
Just that I blacked out and I don't remember much.
Well, turning to case number 24-4039, this is the one the defendant is on a delay of sentence. We've treated this as a probation violation, but technically it's a delay of sentence violation. It does look like Judge Van Alt sentenced her to 1 day jail with 1 day credit, but also on a delay of sentence. So I am going to revoke the delay. And we show she has 14 days credit on this file. So it'll be 14 days of jail with 14 days credit. Fines and costs preserved if there are any left. Then turning to the new file, 254578 FY. When I arraigned her, I had given her a PR bond, but the magistrate arraigned on the violation file. She was remanded, so she only has 1 day credit on the domestic violence file. In that case, there is a $75 Crime Victims' Rights Fund fee, $50 state minimum fee. The court, due to the defendant's employment status, will waive fines, costs. I'll also waive the attorney fees. I am taking into account, even though she isn't entitled to credit, I am taking into account the time she sat on the probation violation. I don't find Ms. Gunn is a good candidate for probation. That was laid out in the last case. So I'm not going to sentence her to probation. I will do 1 day jail with 1 day credit. Now, Ms. Gunn, what that means is at some point today, you're going to be released from the jail and you're not going to be on probation anymore. It's going to be up to you to make sure that you're taking care of your mental health and any drinking issues that you have going on. Do you understand that? Any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. And because I did sentence you to jail, even though it's time served, you do have the right to appeal that decision. If you decided you wanted to appeal it and could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. Okay?
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.